Good afternoon, everyone. I'm Christina Ramirez, and I'm the host of today's Surrogate session, Drafting a Will, with Surrogate Heather Darling and Deputy Surrogate Chris Luongo. Before we get started, I just want to point out a couple of housekeeping items. All participants are muted. You have the ability to ask questions by typing them in throughout the program, and the panelists will answer the questions after the presentation is complete. You will see on the right side of your screen a Q&A, and you should just be able to easily type them in, and I'll receive the questions and I will read them at the end of the presentation. Also, so that you know, we are recording today's session, and it will be available on the Surrogate's website at a later date, and that is at morrissurrogate.com. Now, what I'd like to do is introduce to you Surrogate Heather Darling. She is an attorney and former Morris County freeholder. Surrogate Darling was elected and took office in January of 2020. And with the surrogate today is our Deputy Surrogate Chris Luongo, who is also an attorney. Mr. Luongo has been in the Morris County Deputy Surrogate for 25 years. So I will now turn the program over to the surrogate and the deputy. And I just want you to remember that you can type in your questions throughout the program. Okay.
All right, good afternoon, everyone. Thank you for joining us today. This is our first in a series of programs designed to educate people on various aspects of estates, estate planning, surrogate's office procedure, and a little bit of history with the surrogate's office. So today we're going to focus primarily on wills. And everybody should know that it's best to put your wishes down when you're not stressed, when you're of sound mind, you're thinking clearly. So we don't want people to be afraid to prepare wills. That's something that happens when people think that by preparing a will, you're marking your fate, you're marking your destiny. That's not at all what it's about. It's about being smart when you prepare a will. So what is a will? A will is a legal document that sets forth your wishes rather than having the laws of intestacy, which Chris will get into later, determine where your assets go, because you work very hard for them, obviously. And also sets forth not only where your assets go, but who you choose to distribute them, rather than having an administrator appointed, again, by law, and maybe not necessarily the person that you want. So a will can be brief and still be valid. I've seen them between one page and a whole volume. And it depends on exactly what you want to put in it, how detailed you want to get, and that's really up to you. The reason for making a will is, again, so that your intent is carried out. And I'm going to tell you a little story. There was a gentleman who was mentally incompetent that fathered a child in the 1970s. Nobody knew about this child, and the gentleman himself did not know the difference between a child and a puppy. So the mother of the child found another man, said that the child was his, that it was someone else. She was dating a different guy. She said, the child is yours. The guy put his name on the birth certificate. Nobody knows anything about it. 40 years later, the mentally incompetent man is brutally murdered in his home. And Junior shows up at the funeral with Mommy looking to claim the assets. By then, the father who raised the child, who put his name on the birth certificate, was deceased. So no one was alive to tell the story of what the real intent was, except the mother. No will had been prepared. It was a situation that the man was mentally incompetent. So had he prepared a will, validity would have been challenged to begin with. DNA evidence proved, when the child filed a caveat to administration that the sister was seeking, that this was in fact a child, and the laws of intestacy determined that he would inherit everything in the man's estate. One might think that a mentally incompetent man might not have a large estate, but that was contrary, because we did not then have the stigma-free initiatives that we have in place today. As a result, the family did everything they could to make him look like a legitimate businessman. So they would put him in an office where the public would see him sitting, but not have interaction. And they worked a business for him, a family business, So the gentleman died with about $1 million in assets between his home and his investments, all of which ultimately passed to this illegitimate child that the man never actually knew. And that was clearly not what the family would have intended. And in fairness, the child was now 40 years old and had opportunity to have amassed assets on his own. So it was a really tragic result for the family. And that's exactly why you should have a will, because you never know who's going to come forward and make a challenge. And whether it's a valid challenge or not, the court is going to make that determination, and case law precedent is going to make the determinations or help the judge make the determinations by which your family will ultimately be bound. So who's involved in preparing a will? You have a lawyer, hopefully, because you want to make sure that someone is explaining to you this process and asking you the questions that need to be asked that aren't necessarily set forth when you go online and get a program. You need the testator or the testatrix, depending on gender. So the testator is the person who makes the will. They're called the decedent after they pass. You need witnesses to sign the will, 2 of them, and you also need an executor as well as beneficiaries set forth. And you should always alert your executor to the fact that they are going to be the executor, and Chris will get into that. Chris, if you want to talk about some of the pitfalls surrounding not having a will.
Sure. Thanks, Heather. When you have a will, it's called dying intestate. When you don't have a will, it's called dying intestate. And if you don't have a will, the state of New Jersey basically writes one for you, which means that this state, like all states, have a statutory scheme for which your property is distributed. The scheme is based on the presumption of affection. Basically, the state presumes you love your relatives. So if you die without a will, your relatives, i.e. your spouse, your parents, your siblings, or your children, will be the beneficiaries of your estate. What they receive depends on the status relative to you, relative to the decedent. Most of the time, this makes sense. Sometimes it doesn't. For example, if you're married and your deceased spouse, you and your deceased spouse have children together, you as the surviving spouse would get everything. That makes sense. However, for example, if you're married and you and your spouse dies without any children, and your spouse's parents survive, you as the surviving spouse would receive the majority of the estate, but the law presumes that you'd want your in-laws to get a portion of that estate as well. It's a smaller portion. So that, I'm not sure if that makes sense or not, but that's what the law presumes. This was also applied, for example, if your deceased spouse had children from a prior marriage. You, as the surviving spouse, would receive the majority of the estate, but the state presumes that you want to give the stepchildren a portion of the estate as well. That may not make sense to you as the surviving spouse. If you're not married and you have children, your children would get everything. That certainly makes sense. Now, if you're not married without children, your parents would get everything. And if you don't have parents, your siblings would get everything. So let's say you die and you don't have any relatives whatsoever. In that case, the state of New Jersey would be the beneficiary of your estate. That's called a escheat. It rarely happens. So there's 3 advantages to having a will. First, it's your money. You should decide where it goes. You may have a charity you're interested in. You may have a different relationship with your children. It's either way, it's your money. You should decide. Second, without a will, it can be costly. What that means, if you don't have a will, an administrator has to be appointed by the surrogate, in this case, Heather. Your heirs would be your descendants, again, depending on your relationship, or whether you're a spouse or children. but the administrator would have to be appointed by us. Now, it gets costly because we typically require an administrator to be bonded. We require the administrator to get a surety bond. It's basically an insurance policy. If you have a will, for example, the executor is typically not bonded. So when you don't have a will and the administrator comes to our office, we will bond that administrator. And that's based upon the amount of assets. The reason why, again, is the surety bond is to require the faithful performance of the duties of the administrator. The surety bond costs money. For example, a $100,000 bond costs $460 a year. $1 million bond costs $2,100 a year. It does come out of the estate, but it's still costly. And at the end of the case, you may have to discharge the bond. Sometimes the surety company allows you to discharge it with an affidavit. Sometimes you have to go to court. So bottom line is, it's better to have an executor appointed, better to have a will, and you can appoint the executor. And most of the times we do not bond the estate, the executor. The final reason to have a will is because for privacy. If you die without a will, you have to come to the surrogate's office and you have to disclose your assets. Someone has to disclose the assets of your estate. That may not be your intent. So to ensure your privacy, it's good to have a will. So those are basically the reasons to have a will. Obviously, the cost, privacy, and the decision to make decisions regarding your own property. Do you want to continue with it?
Sure. Some key words that you need to understand when you're preparing a will. The testator. Again, that is the person who's drafting the will. Masculine testator, female testatrix, depending. It's gender neutral at the end of the document in case anyone drafts incorrectly with regard to any individual named under the will. Beneficiary is a person who receives your assets, who is to receive under the will. This is not necessarily an heir because you're choosing these people. So heirs at law are people according to lineage in most cases, as opposed to the beneficiary, someone you choose. Executor is the person who carries out your intent under the will, and Chris is going to go into a bit about who that is, how you choose them, and why. But first, I want to go over the types of wills. First, you have a standard will. It's handwritten, or typewritten. It's signed by the testator, and it's witnessed by two individuals, and it contains an attestation clause indicating that this is, in fact, your last will. Self-proving will is the same as a standard will, only it contains an affidavit and acknowledgement clause indicating that certain circumstances took place at the time that the will was signed to make it self-proving. Holographic is the proverbial write it on a cocktail napkin as your plane is crashing toward the ground or plummeting toward the ground, and this is admitted into probate only via superior court. So it is subject to considerable challenge. It's the most often challenged in New Jersey. And Chris, if you want to talk further about the executor and executrix.
Sure. The executor is someone who you trust who will carry out the written instructions you've given in your will. So by definition, you have to trust the executor. A couple things to be aware of. The executor is imbued with great powers. And the reason why is that we want the executor to be able to distribute the property in the way you want in your will. For example, the executor can sell your property. It can file a lawsuit on behalf of the estate. The executor, believe it or not, can even borrow money against the estate. So the powers of the executor are great and vast and are designed to give the executor the ability and flexibility to carry out your intentions. A couple of tips here. First, if you are naming an executor in your will, you should make sure that you tell that person that they are the executor. For example, my wife is the executor of her cousin's estate. My wife's cousin is older than my wife, by 25 years. And my wife's cousin told her that, and which is good, because if my wife wasn't informed of that, she probably wouldn't presume that she's named as the executor. Now she's on notice, and now, God forbid, anything happens to my wife's cousin or her spouse, she'll be able to step in. So again, the person you name as executor in will, you should tell them that they are the executor. The corollary to that is that person should be willing to serve. If you tell someone they're the executor and they don't want to serve, that doesn't serve anyone's purpose. You should also have two alternative executors named in the will in case that named executor dies. If the executor, if all the executors die in a will, the surrogate can name an administrator CTA, but all parties in the will have to agree. A couple of other tips. The executor should be age appropriate. That is, you don't want, if you're younger, on the younger side, you want to make sure the executor is either your age or younger, so in case you die, they are able to serve. And that executor should also be geographically appropriate. You don't want to name someone in California to administer your New Jersey estate if they're not going to be able to do it. So they should be age appropriate and geographically appropriate as well. One other thing, the executor is paid. Because it's a big position under the law, the executor is paid a commission. The commission is based on the size of the assets. For example, the executor is paid 5% on the first $200,000 of an estate. Anything above $200,000 up to $1 million, that executor is paid 3.5%. Anything above $1 million, that executor is paid 2%. So the executor is paid, can be paid a significant sum of money. The executor is also compensated 6% of any income received. Now, the executor also has the authority to hire attorneys, which should come out of the estate, and hire an accountant as well. So the executor does have a discretion to hire professionals. So be careful who you choose. Now, the majority of the estates we deal with, and I deal with the contested probates, go on without a hitch. But at least 60% of our cases involve not will contests, but believe it or not, executors who don't do their jobs. For whatever reason, either they delay in making payments, or they fail to account, or they do other things that require judicial intervention. So again, it's very important to pick an appropriate executor. Now, Heather, do you want to go on from here?
Sure. The next thing is caveat. Caveat is a formal challenge to an estate. A caveat is filed to put the judiciary, to put the surrogate's office on notice that someone is challenging either the executor or the administrator of this estate. Going back to the example I gave at the beginning, this long lost child who came back looking for his father's money filed a caveat, and that's how he became involved in the court, and that's ultimately how the money was given to him. Had he not filed that caveat, then the sister would have been allowed to proceed with the administration of the estate, and the assets would have been distributed to the siblings according to what the administrator was advising the surrogate's office. So it's a very, very important document if you believe that you do have a valid challenge and you want to make sure that you seek counsel immediately and get that done. Somebody has to wait 10 days after a person's death to begin to probate an estate. So that's not a very long amount of time, 10 days. And if it's a simple estate, it can be wound up with assets distributed in a very short amount of time. So if you intend to file a caveat, while you have time to do so, you should not necessarily take any extra time beyond what you need. Now, as far as what should be included in a will, we talked about the executor and the executrix. Chris went into who and how you make the choices. Beneficiaries is something that's very interesting because people say, I'll divide it in thirds, I'll give this one a house, and then I'll give everybody thirds after that, or various decisions that are made, but you have to go into it thinking what's fair. So perhaps you have a child that has been estranged but has done financially well for themselves. So you feel that maybe they shouldn't get what the other kids get because the other kids need it more or the other kids were there more for them. So this is something where you really have to sit down and think. It goes deeper than dividing it into thirds or halves or whatever it may be. Also, if you have somebody who's special to you, maybe you had a collection of sorts and you want to leave that collection to the person that you enjoyed it with. Say you had a grandchild that greatly enjoyed working on some classic cars with you. Maybe you want to give that car to the grandchild instead of letting it go in your estate. However, I have people that come, well, used to when I was practicing, come to my office and say they want to make a will and they have a list of assets and they have their 1989 Ford Bronco or something in there that's their daily driver and they're 50 years old and they want to give that to their kid. Well, the odds that that particular Ford Bronco is still going to be running at the time that this person passes is relatively slim. So when you're going through your assets, think about the larger things, the more important, the more significant things that will still be in your life. And odds are that car won't. So you may just want to say my automobiles to a certain person or let them be sold and divided collectively. So those are some things to consider. And also something that is only legal when it's in your will, but I don't believe makes sense to put in your will necessarily. Chris and I differ on this. If you have a funeral, a burial plot, a place that you'd like to use for your funeral, if you want to be buried or cremated, you can put that in your will and that has legal standing. However, as I indicated, you cannot probate a will until 10 days after the decedent is deceased. So what that means is there's a good chance that this person has been buried, cremated, their life has been celebrated and remembered. There's already been a funeral parlor that's been utilized for that. All these decisions have already been made. And if it is in the will and you're seeing this for the first time in a will, it may be too late. Now, a living will, healthcare directive is something that many people also prepare with their estate planning documents, not really a subject for today, but usually if there's a last illness, that would be prepared and would be in the hospital with the person so that somebody would see it sooner than later before it's too late. So to cover your bases, I would say put it in both places. Chris, if you want to talk about minor children.
Sure, and I also want to bring up one other issue. Heather mentioned about filing a caveat. If you seek to contest your will before it's probated, as Heather mentioned, you would file a caveat. And that's basically just a short pleading indicating you're protesting the will. If you want to contest a will after the probate has been issued, you should be aware that there's a very short statute of limitations. It's 4 months. If you want to contest a will, it's 4 months after the date of probate. It can be extended for 30 days upon good cause. And that's if you live in state. And if you want to contest and you live out of state, you have 6 months. So just be aware, there's 2 ways to contest a will. One is to file a caveat before the will is probated. The other way is to file a will contest. But again, the statute of limitations or the time to file, the time to contest a will is very brief. Now, as Heather said, if you have minor children, you may want to also include a guardian who will serve in the event both you and your spouse pass on. Now, that's a very rare event, although it has happened in Morris County. You may want to put it on notice or put it on record in your will that you want X person to serve as your children's guardian. Again, just like the executor, you should let that person know that they are named so they're aware of it and they're to look out for it. Again, that's a very rare circumstance, but it's something you should consider if you have minor children. Now, Heather, do you want to discuss about what it is to prepare a will?
Sure. So we've gone over the contents of it, and that involves gathering the information and making the decisions with regard to who gets things and who will carry out your wishes, which again would be the executor. And then another question is, do you need or want an attorney? And again, as I indicated a few minutes ago, with regard to an attorney, you have somebody who knows what questions to ask you to elicit certain thoughts. Many people come in with their decisions made without realizing the questions that they really should be asking. And the difference between filling in the blanks in a computer package and actually working with an attorney who knows to ask you those questions can be a great consequence to your beneficiaries and even to your executor in the future. Oftentimes, when you don't have an attorney, things are left improperly done, inadequately stated, and litigation has to take place in order to remedy that. So it is something that's a significant decision. And when you look at the amount of assets that you're dealing with, where you've got a house, you've got some savings, some vehicles, perhaps some investments, you could be looking at hundreds of thousands, if not millions of dollars. And to not spend a few $100s to $1,000 on an attorney to prepare a will to handle all of that properly is just penny wise and dollar foolish. So I would ask you to strongly consider. And also for those of you who can't afford full service legal prices, we have partnered with the Morris County Bar to handle things that go through our office as well for the reduced rate attorney program. Chris will give you the number in a second, but if you qualify financially, the bar will give you someone who can help you with that. Chris, you want to give the phone number?
Sure. The Morris County Bar Association has a loyal referral service, which will refer you to a lawyer who will draft a will if you'd like. And they also have a reduced fee program as well, but that's based upon income requirements. The phone number is 973-267-5882. And they're very helpful over there. And they'll be able to help you get a list of lawyers you can choose from. Is there anybody to ask some questions?
I hope that you have all received some information that was beneficial today. We want you to understand that, again, this is basic. There was a lot of repetition, and it's because it may seem daunting because of the nature of the subject matter, but preparing a will does not have to be a difficult experience. And I hope that through what we've discussed today, we have taken a little bit of the mystery out of it and made some of the things very clear and very obvious to you. And we've also kept our program relatively short so that we allow time for questions, because we understand that we're saying the same rhetoric you may have heard or read when you were looking for information, but you may have questions that you've been waiting to ask us. So we're happy to answer them at this time. And I want to thank Chris for doing a great job on this today.
Okay, thank you, Heather and Chris. That was really great. And we do have a number of questions that have come in. So why don't we start with those? The first one is, can the beneficiary also be an executor?
Yes, beneficiary can be an executor. There's no issue with that. And it can be. Yes, that's the basic answer.
Okay. And I have two questions that are alike, so I'm going to ask it in one question. What is the difference between an administrator, an executor, and a trustee?
So an executor is somebody who is appointed under the will. An administrator is someone who's appointed by the surrogate's court in the event that either there is no will or the executors under the will are deceased, for some reason unavailable, all renounced, maybe are not of sound mind and not able to act. then somebody would seek to be appointed the administrator of the estate, and that would be done through this office. A trustee is someone who manages the assets of the estate on someone else's behalf. So assets that are distributed go through the will and they're distributed to beneficiaries. Assets that go through the will to a trustee are then held in trust for a certain person. Typically, it's a minor or an individual with special needs for which assets would be held in trust.
Okay. Here's another one. What happens when or after a will is probated?
Interesting.
After a will is probated, you have to wait 10 days after the person dies. If the will is probated, you would come into the surrogate's court, the executor would be appointed. And then at that point, the executor would start marshaling the assets of the estate. And that obviously is going to all the banks, selling any real estate, maybe talking to the decedent's accountant to see if there's what assets the person has. And then at that point, after they marshal the assets of the estate, they have to carry out the intentions of the decedent in the will. So after a certain amount of time, usually 9 months, they would start making distributions. Now, the executor also has to pay any creditors. The executor, as I stated before, has great discretion, so they can compromise claims if there's a disputed claim. But at some point, they have to pay all the claims, pay all the creditors, and then distribute the money that's left over to the beneficiaries, and that's after paying themselves an executor commission.
Also, with regard to that, a note when you're preparing a will. Something that you want to do is you want to keep with your will, which I'm sure will come up later, so I'll save it. But you want to keep with your will a list of where your accounts are located, who your attorney is, who your financial advisor is, who your accountant is, because it makes it much easier. As Chris said, they're working with the person's accountant, the executor's doing all these things. It's much easier if they have a list that tells them where to go to find what they need to find, and that's kept with the will. Another thing that Chris left out is there's frequently an accounting that's done on an estate by the executor or by an accountant that, as Chris said, the executor has discretion to employ. And the accounting will be done, it can be either informal or either formal or informal, depending on the circumstances and the level of contest in the estate. But it's designed to show exactly what existed in the estate and how it was distributed so that everyone knows that it's being done fairly.
Okay. And then you talked about this 9 months. The question is, after filing income taxes, is there an income tax situation that the executor has to worry about?
If the decedent didn't file income taxes for the year that they died, they have to file income taxes. Now, there could be estate taxes if it's a very sizable estate. There could be inheritance taxes depending on the beneficiary, and there could be New Jersey estate taxes. So there could be income taxes, federal estate taxes, state estate taxes, and transfer inheritance tax depending on the beneficiary. Estate taxation is a huge topic that's really not designed for.
So the taxes would be paid prior to any distribution to beneficiaries?
That's correct.
Correct.
Not of the question. Okay. All right, another question. So you talked about guardianship for minor children. The question is about pet care. Do I care for my pets in my will? And who will take care of them? Can you talk a little bit about that?
The pet lover will answer that question.
So absolutely. When it comes to pets, those of us who have them, it's very near and dear to us, and we want to make sure that our furry friends are taken care of. So what people do is, if they want to make sure, they make trusts, and there's been ample litigation on this as to the legality of how much you can leave to a pet or in trust for a pet, can you leave money to a pet when a pet is not a person? And essentially, no, you leave money in trust and you have a trustee who may provide money to the caregiver of the pet so that there's a system of checks and balances to make sure that the pet is being properly cared for in the residence that they're supposed to be caring for the pet, to make sure that the pet is still alive and the person's not spending the money. Or depending on the level of trust and who you've chosen, you may give the money to someone outright with the understanding that they're going to take care of your pet. But now, if they spend all of the money and don't have any left for your pet, then what's the level of care your pet's going to get? So it's to those of us who have pets that we care dearly for, it's as important as choosing a guardian and setting up a trust for your child.
Okay. So another question is, what should an executor know about my will? What should my executor know about my will? What details?
There's no reason and there's no obligation to tell an executor how much money you have or disclose your private assets. That's not necessary. You should just tell the person that they are named the executor of the will and where the will is located. So those are the two basic things that they should know, be notified that there is a will. The will is in my house, on wherever that is, and that they are named as executor.
And that gets to the next question. Where should I keep my will?
Never, ever, ever in a safety deposit box because somebody can't get there to get it. So you want to keep it somewhere safe, not necessarily in a safe, unless that person has the keys to your house, but not the combo to has the combo to the safe, but not the keys to the house. And then they can get the keys to the house from someone else to utilize the combo to the safe. You don't necessarily want somebody looking at your will before they need to be. So it's up to the discretion of the individual, depending on who's going to see it. If you have kids that might fight over assets and you don't want to see that happen, you want everything to be peaceful during your lifetime, you probably don't want to leave it with one of your kids if you think that's a consequence. Somewhere fireproof, somewhere that's not likely to be flooded, and again, not in the safety deposit box because you can't get in there. Chris, if you want to talk a little bit about how.
It's a great question because we probably like 5 or 6 times per year, we have people who go to banks and they say to the bank, well, we believe the will is in the safety deposit box in the bank. The problem is the safety deposit box is owned by the decedent. So how do you get into the safety deposit box? We don't know whether who the executor is, or even if there's a will in there. It's like the chicken and the egg, so to speak. So we've designed a way at the Morris County Surrogate, we have an order that allows a potential executor or a family member to go into the safety deposit box, but it's a pain in the neck. So that's why it's very important to keep the will obviously hidden, but in a place that's accessible. And as Heather mentioned before, the bank is not necessarily the best place, although it's a safe place, but it does present its own problems. So it's a very tough question. It's of all the questions, it's one of the more difficult ones, even though it's kind of basic. So.
Okay. Is a will for an individual, or can one be drafted for a married couple?
It's individual. You should never draft one for a married couple, because once the married couple comes in, it can only be for one person. So if the will is probated for the husband, the wife shouldn't be bound for what she's going to do with her property. She's free to change her will. So if the will is probated, she can certainly do it, but it just adds confusion. So it should only be for one person.
Okay. And someone's asking what the difference is between a will and a living will.
A will is something that becomes effective after you pass. A living will, otherwise known as an advance directive, and several other names, is something that is designed for carrying out your wishes with regard to medical procedures that may have to be done in the event of a medical emergency where you're not capable of expressing your wishes. So, for example, if you were in a car accident and were temporarily in a coma, if you had a living will, then that would say do not resuscitate, things that you would want done, intubate, don't intubate, and you would most likely appoint someone who would make temporary decisions like, should we do a tracheotomy? If we need to do a tracheotomy to keep this person alive for a certain amount of time, while we do these other procedures to bring them back. And you, it's a very different area that we may at some point cover during one of our sessions. We haven't made the decision on that yet, but one is, to make it easy, one is medical decisions during your lifetime. The other one is property decisions after your death.
So the question is, do you need both a will and a living will?
We always recommended it when I was still practicing. It's better to have everything in place, because certainly during your lifetime, if someone's capable of making medical decisions for you and really understands you, your wishes, and your intent, you absolutely should have it. The example that I often give is, if you are somebody who has a severe incurable illness and every day is suffering to you, you may have very different decisions about whether you want to be kept alive by artificial means than somebody who's in their 20s that's otherwise healthy with their whole life ahead of them, who's in a car accident. And throughout your life, different circumstances would dictate what your decisions might be on that. But we always advise having both, as well as a power of attorney, which is a third and very distinct document in and of itself.
Okay. I know that you've both talked about the importance of having an attorney help you with the will. The question is, are lawyers absolutely needed to have a legal will? And what if you download a will from the internet and have witnesses when, sign it when it's completed?
You don't have to have a lawyer to draft a will, to execute a will, and there's certain wills you can get online that are satisfactory. The problem is there's no guarantee that it's done correctly. By having a will, hiring a lawyer who specializes in this, or even a general practitioner, you're basically assured that it's going to be done right. So it's really the peace of mind in hiring a professional. Do lawyers screw things up occasionally? But most of the lawyers in Morris County are tremendous. So I would, you're certainly free to do it yourself. You're certainly free to get documents off the online, but my recommendation would be to hire a professional.
So here's another one. It's more of a statement asking if this is true. Named executors can be changed, not fixed forever, correct? If so, the testator and the witnesses would need to re-sign, correct? Just like a beneficiary can change due to circumstances. Are these true statements? So you can change, I'll say it again. So you can change an executor in your will, correct? And you can change, if you do, then do you need to have it re-signed, the will?
Given the import of the executor to the will, to avoid any potential question, I would strongly suggest having a new will drafted up or preparing a codicil to the will rather than making the change, although it's not necessary. Chris, if you want to go further, some of the experiences on that.
You could change an executor at any time prior to your death. But just understand that the executor, again, has great powers, and that your executor could be in jail, and that wouldn't disqualify the person to be an executor. The executor could have a criminal record, and that wouldn't disqualify him or her. So you have to be careful who you choose, and it's once that executor is appointed after you die, and then we appoint the executor, It's very tough to remove an executor. There's a very specific criteria for removing an executor. And again, my hypothetical is that an executor could serve from jail. That's not what you want. So you can change the executor, just be careful who you choose. And once the executor is appointed by the court, tough to get rid of him or her.
So you spoke of a codicil. The question is, can you describe what a codicil is?
Is a document that would make a change to the will. For example, you may want to add beneficiaries, you may want to remove beneficiaries, you may want to change an executor or an executrix. Any change that you want to make could be made in a codicil rather than drafting a new will. And the codicil has to be dated, signed according to the circumstances in which the will was signed in order to be valid. In most cases, it could be presented, then it would be subject to litigation if it wasn't properly signed. Again, I don't object to a codicil, but I strongly recommend, more often than not, redrafting the will if at all possible.
Because you actually having a codicil, you double your chances of one of the documents being missing. So it's probably, as Heather said, it's better just to do a new will.
So are there steps that which must be taken to find missing heirs? And at what point does a missing heir's share go to his or her issue? It says his or her.
Well, missing.
Or the other, I guess the other beneficiaries is what they mean.
Missing is an interesting term because missing is not deceased. So to go and distribute to the heirs, of that individual, there's a presumption that that individual is no longer with us. Otherwise, the distribution would be very difficult to make. In the event of an heir not being able to be located, many times the property will escheat to the state, depending on what the circumstances are. If you have all reasonable presumption that the person is deceased, there's a legal way to file that. When it comes to a missing person, there's just no presumption that that property can be passed forward. Chris, if you want to talk about some cases or anything that came up.
Sure. If missing again is like a term of art, because they're missing, you could conceivably get a declaration of death, and that would end it. If you can't find an heir, let's say you know the person is alive, you just can't find him in the state of Hawaii. What an executor would do, they would just send that money to the state unclaimed property after a certain amount of time. So if there's an administration and you can't find an heir, there's actually a process by which you can disinherit that missing heir, but it's a long process. So in other words, if there's an escheat, if there's an administration, there's 4 children, and you can't find the 4th child for whatever reason, you could, after due diligence and you go to court, seek to have that person's property distributed to the other 3 beneficiaries. But that's a very unique circumstance. So if you can't find them, can't find a person, typically it goes to unclaimed property. And you have the option, obviously, to have that person declared dead. But again, that's very, very, very rare.
Okay. Another question is, after you die or the person dies, can the beneficiaries get access to the will from an attorney who wrote it? Will the attorney release that to beneficiaries?
Beneficiaries typically contact our office to get it. I've heard of attorneys giving it to the beneficiaries. I think it probably depends on the relationship between the attorneys and the beneficiaries. But it is on file here in our office, and that is where you would come to get it.
But the executor has an obligation under the law to provide a copy of the will to the beneficiaries. So as Heather said, you can go around that by asking us for it, but the beneficiary could ask the executor to produce a copy of a will, and they're obligated to give it to them.
but they have to know they're a beneficiary. Some people assume they're a beneficiary only to find out later that they're not. And those are the ones that usually come here looking, or the ones that the executor couldn't find that learn of the passing.
Okay. Can you tell us again what a holographic will means, or a letter of administration?
So a holographic will is a will, again, it's the proverbial back of the cocktail napkin when the plane is plummeting to the ground. It's something written in the testator's handwriting, typically, that is not properly witnessed, and it really has no indicia of credibility to it. So that's something that's heavily subject to question in the court. What was the second part of that, Chris? Sorry.
A letter of administration?
Letters of administration is something that is issued by our office to the administrator. It's the same as the letters testamentary being issued to the executor. That's not something that a testator prepares or an administrator prepares. That's something that is generated. It's a certificate that comes specifically from our office.
So it's coming up on 12:51, so I think we have one or two more questions, and then we'll, turn it back over to you all to do a summary. But I think you talked a little bit about funeral wishes earlier, and you two do not agree. So the question is, should I put the funeral wishes in my will?
You should put them, you should put your funeral wishes in your will, and you should also create a separate document that indicates what you want done with your funeral. And what do you want done with your body? Do you want it cremated? Do you want to be buried? It's very important that there's some writing, some indicia, so your heirs can make that decision what you want done with your body. In the absence of the executor has the authority to make those decisions. Funeral home directors generally rely on the spouse, what the spouse wants. If the spouse is not available, it's the majority of the heirs. So that's the law.
Okay. And then what is a self-proving will is another question we have here.
The self-proving will, like we talked about earlier, it's the standard will that's been signed by the testator. It's been signed by two witnesses. It's been witnessed by a notary. And it has a special clause that indicates that certain things were stated at the signing, 18 years old, of sound mind. These are your last wishes, and everything was done properly. And what that does is it prevents you from having to go, or the executor from having to go and find one of the witnesses to the will to come and attest by signing something that they were in fact there at the time that the will was signed, and this was stated as the last wishes of the testator. Barring that not being done, we have to find, or somebody has to find one of the witnesses and take care of this. They may be out of state. It may require some mailing. Maybe they lack capacity to respond to the questions at this point. So it's always better to have a self-proving will.
Okay. And here's one more. Does the county keep, meaning your office, keep the original will or return it to the executor? Is the executor provided copies of a will?
Executor, we do keep the original will, and we do give a copy back. However, you may want to make a copy before you come to our office anyway, just for your records. So yes, we do keep the original. That's the law.
Okay. So at this point, I'm going to remind everyone, or thank everyone for joining today, and I'm going to turn it back over to the surrogate, and maybe you can tell folks how they can get started in getting their will done. I've had some comments from some of the participants saying this is really great, and then I have to get working on it, so maybe you can advise them on how to get started. I'll remind them that they can call the Bar Association at 973-267-5882. If they have any other questions they want to ask us, they can go to surrogate@co.morris.nj.us and email us any additional questions that you might have after the program. But Surrogate, I'm going to turn it over to you.
Chris and Chris, I want to thank you both for everything you've done to make this happen today. Everyone who joined us during your lunch today, I appreciate you being here. I'm happy that you learned something. I think you guys had a lot of great questions, which indicates that either Chris and I need to prepare better, or we at least made you think, which is important. So as Christina indicated, there is a way that you can send us questions as far as getting moving on this. Again, you can contact the bar, you can contact whatever attorney you normally use to handle your affairs so that they can begin drafting, get your thoughts together, gather the information. That's something that's very important. Speak to people that you may want to be your executor so that when you write it down, you can write it down with confidence. If you're going to do a power of attorney and a living will, start thinking about the people very similar to executor, who's going to handle some big decisions. So think about who you want doing those things. Chris, anything you want to add?
No, that's exactly right. And then we're just gonna give you our phone number, which is 973-285-6500, which is the phone number of the surrogate. And if you have any questions, you can call us or email us. We have moresurrogate.com is our website. And I know Heather, the surrogate darling, is very accessible, and as well as myself. So if you have any questions, feel free to contact us.
One last thing I do want to add, I believe Christina has an email sign-up list. If anybody's interested in coming to attending in this fashion, future sessions that we do plan to have, please give Christina your information so that we can follow up with you and let you know about future sessions, because some of the information that we're giving out is going to be relevant to some of you, some to others, but the intent is really to educate you. So any feedback that you want to give us as well, we greatly appreciate it. And thank you all again.
Thank you.
Thank you, everyone. Have a great day.